All right, thank goodness the air conditioning is on. Today is March 11. This is a meeting of the Cities and County Subcommittee. If you have business before us, please stay. Welcome members and guests. Committee will be in order. Madam Clerk, open the voting board to take the roll. And it'll take us a moment for everybody to get signed in. Madam Clerk, take the roll.
Mr. Chairman, you have 5 members present. You have a quorum.
Thank you, Madam Clerk. We will go ahead. Does any members have any personal orders or announcements? Members will realize that the chair did provide dinner tonight. It's at your microphone. So I can't keep up with the comptroller, so that's the way it is. Anyone else have any announcements? All right, we'll take up today's calendar. Item 1 is House Bill 2509 by Chairman Faison.
Good afternoon, committee. Some of you.
Madam, we have a proper motion second
Mr.
on the
Chair.
bill. Chairman Faison, do you have an amendment on the bill? 14834.
Well, I've got the right bill here in front of me. If you say I have one, Mr. Chairman, I'll say okay.
No, doesn't work like that. 14834.
Is this House Bill 2509?
Yes, sir, it is.
Yes, sir.
They have a motion on the amendment. I have a motion and a second on the amendment. Chairman Faison, you're recognized on amendment 14834.
Thank you, Mr. Chair. Committee, glad to be with y'all. As each one of you know, we have had issues when it comes to housing for people in middle and just under middle income. It's a problem. Our speaker has come up with a program that's going to be a $10 million pilot project that we send to the THCA that will be spread out through all 3 grand divisions. And it's a grant process that developers can use to build housing for somebody in that, I'd call it like a tweener. They're not rich and they're not poor. They're struggling, and it costs a lot to find housing. And if your community, your city, your county is being forward progressive thinking of how to be innovative when it comes to meeting the housing challenge and housing crisis, you can apply for a grant to do something like this. And that's what the bill does. It has to be relooked at, analyzed in 2027 to make sure it worked and see if it did work good enough, potentially to re-up it and bring some more money in.
Thank you. Questions on the amendment? Discussion on the amendment? Hearing none. Is there objection to the question? Hearing none. If you're in favor of amendment 14834, say aye. Aye. Opposed, say no. The ayes prevail. The amendment goes on bill 2509. Mr. Chairman Faison, you are recognized for any
Question
follow-up.
on the bill.
Out of order. Representative Dixie, Representative Dixie, you're recognized.
Bill, I do have a serious question.
Yes,
Now,
sir.
I just wanted to make sure, because in here it says the agency to provide loans, and you use the word grant. And if it's going to be a grant, that's fine. And if it's a loan, is it like a low-cost loan?
Chairman Faison.
Yeah, thank you, Mr. Chair. It is. Yeah, it's like a zero interest.
Okay, but it is a loan.
Representative Dixie.
Thank you. I appreciate that.
All right. Any other questions or comments? Is there objection to the question? Hearing none, we're now voting on House Bill 2509 as amended. Madam Clerk, open the rolls for voting. Let every member please cast their vote. Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 6 ayes and 0 noes.
The ayes prevail. House Bill 2509 as amended moves next available calendar, state and local government. Item number 2 is House Bill 2538 by Leader Lamberth. And I believe Chairman, second. You have proper motion in a second. You're recognized on House Bill 2538. And
Thank
you
you.
do have an amendment.
Yes, sir, I do.
And it's barcode number.
014138.
We have a motion and we have a motion and a second on the amendment. Does it rewrite the bill, Mr. Sponsor?
Yes.
It does.
That's right.
All right, if
It
you'll
does,
explain
yes,
the
sir.
amendment.
Yes, sir. As written, this legislation authorizes the Mega Site Authority of West Tennessee to issue bonds, placing it on equal footing with other municipalities under state law, enabling it to fund unbudgeted water and wastewater system repairs quickly in the event of a disaster, minimizing service disruptions.
You've heard the explanation of the amendments or questions or comments. Is there objection to the question? Hearing none. All in favor of amendment 14138, say aye. Opposed, say no. The ayes prevail. The amendment's on the bill. Is there any further discussion on House Bill 2538 as amended? Chairman Crawford, you're recognized.
Thank you, Mr. Chairman. In the amendment, it talks about the authorities board. Is that a different board than the Blue
Mr.
Oval board?
Mr. Sponsor.
And who appoints its members?
That is a good question. I'm not sure if the department is here. They are. The department is here that could answer those things for us, if you wouldn't mind going out of session.
We shall go out of, without objection, we will go out of session and bring someone up from the department. If you'll please identify yourself and please address the question before us.
Tyler Crosby, Senior Counsel and Legislative Liaison for Department of General Services. With me, I have Clay Brout, the Executive Director of the Mega Site. Mr. Chairman, to address your question, I believe the amendment, you talk about the State Funding Board. All this would be subject to the review of the State Funding Board.
Chairman Crawford.
Thank you, Mr. Chairman. Is those members appointed by the governor or are they made up of?
I could be wrong, but I think there's the constitutional officers and maybe speakers appointments.
Chairman Crawford.
Thank you, Mr. Chairman. That answers my question. Thank you.
Thank you.
Any other questions while we're out of sessions? Any other questions? Thank you very much.
Thank you,
for
Mr.
help.
Chairman.
We are now back in session. Mr. Bach, you are recognized on the bill as amended.
No further questions.
Is there objection to the question? Hearing and seeing none, we're voting on House Bill 2538 as amended. Madam Clerk, open the board for voting. Members, please cast your vote. Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 6 ayes and 0 noes.
The ayes prevail. House Bill 2538 is amended, moves next available calendar of state and local government.
Thank you, Chairman and Committee.
Item number 3, House Bill 2543 by Leader Lamberth. We have a motion and a second, and I see Chairman Hicks is with us.
Thank you, Mr. Chairman.
And you do not have an amendment, so you're recognized on House Bill 2543.
Thank you, Mr. Chairman and members. House Bill 2543 strengthens Tennessee ability to respond quickly and responsibly when disasters strikes our communities. As disasters become more frequent and recovery costs continue to rise, Tennessee must be prepared to address situations where damage is significant, but federal disaster assistance is unavailable or insufficient. This bill ensures our state has the tools to fill those recovery gaps. The legislation updates the Governor's Response and Recovery Fund by placing program administration with the Tennessee Emergency Management Agency, where the disaster response currently already exists, and it'll be in a very good department. It also establishes 2 clear avenues for assistance. First, the fund can support local governments counties, cities, and school districts recovering from disaster-related damage. These funds can be used for essential services such as debris removal, road and bridge repair, water and sewer systems, public buildings, equipment, and other emergency infrastructure needs. Second, this bill allows limited assistance to individuals when FEMA individual assistance is unavailable, helping families stabilize and recover after a disaster. Importantly, this bill includes strong guardrails. Funding may only be considered when the governor and local government declares a state of emergency, federal aid is unavailable or unlikely, and damage exceeds the threshold established by the TEMA, and the local jurisdiction formally requests assistance. This legislation ensures clear expectations, responsibility, use of taxpayers' dollars, and faster, more flexible aid to communities, particularly rural and smaller jurisdictions that often fall short on federal disaster thresholds. Simply put, this bill helps Tennessee stand ready and helps our communities recover when disaster strikes. And I respectfully ask for your consideration.
Thank you, Chairman Hicks. Questions, comments? Is there objection to the question? Hearing, seeing none, we are now voting on House Bill 2543. Madam Clerk, open the voting board, please. Will every member cast their vote? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 6 ayes and 0 noes.
The ayes prevail. House Bill 2543 moves next available county, state, and local government.
Thank you, Chairman. Thank you, committee.
That brings us to item number 4 on today's calendar. And the sponsor respectfully asks that this bill be rolled to the heel. Is there objection? Seeing or hearing no objection, House Bill 2547 is rolled to the heel. Item 5, House Bill 2552 by Leader Lamberth, and it is being carried by Chairman Williams. Without objection, this bill be rolled to the heel. Hearing no objection, item number 5, House Bill 2552 is rolled to the heel. Brings us to item 6, House Bill 1827 by Chairman Hicks. We have a motion and a second. Your bill is properly before us, Chairman Hicks. You're recognized.
Mr. Chairman, I am still working on this particular bill just a little bit. So if I could I roll it to the hill without objection?
Is there objection to rolling House Bill 1827 to the heel? Hearing no objection, House Bill 1827 is rolled to the heel.
Thank you, Mr. Chairman.
Item 7, House Bill 2207 by Chairman Hicks. We have a motion and a second. Chairman Hicks, you're recognized. Do you have an amendment, sir?
I sure do. Makes the bill 014514.
Is there a motion on amendment? We have a motion and a second. Chairman Hicks, you're recognized on amendment 14514.
Again, it does make the bill, Mr. Chairman. Do you want me to go ahead and explain it?
If you would, please.
All right. Mr. Chairman, House Bill 2207, once it is amended with this amendment, and this bill comes to us from the assessors of property. In section 1 and 2, this will extend the amount of time a church has to get their paperwork filed for exemption from 30 days to 180 days. In section 3 and 4, it clarifies that disaster relief is done by resolution and not ordinance. In section 5 and 6, it clarifies the interest rate is calculated on an annual basis, not monthly. In section 7 and 8, it allows Davidson County to increase the size of the County Board of Equalization from 7 to 12 members. And that is it. And I stand for any questions.
You've heard the explanation of the amendment. Is there any questions or comments or objection to the question? We are voting on amendment 14514. All in favor say aye. Opposed say no. The ayes prevail. And puts us back on House Bill 2207 as amended. Is there any other comments or questions to the sponsor? Is there objection to the question? Hearing none, we are voting on House Bill 2207 as amended. Madam Clerk, open the voting board. Will every member please cast their vote? Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 6 ayes and 0 noes.
The ayes prevail. House Bill 2207 as amended moves to the next available county, state, and local government.
Thank you, Mr. Chairman and members.
Item number 8, House Bill 725 by Chair Lady Helton Haynes. We do have a motion and a second. Chair Lady Haynes, you're recognized on House Bill 725. Do you have an amendment?
I do, Mr. Chairman.
And the amendment number is?
14700.
We have a motion. Did I hear say we have a motion and a second on amendment 14700. You're recognized on the amendment. Does it rewrite the bill?
It does.
Go ahead and explain
Okay.
your amendment.
The Border Region Retail Tourism Development District, enacted in 2011, is a Tennessee law designed to boost economic development in border cities by enabling them to capture a portion of state sales tax to fund large-scale retail or tourism projects. This amendment expands the Border Region Act investment period and reimbursement period for development, which is currently in statute by 5 years. Currently, the investment period is set to end in 2027. But this bill will extend that period to 2032 and the reimbursement period from 2047 to 2052. As a reminder, the Border Region Act applies to areas of Bristol, Kingsport, and East Ridge to drive economic development and serve as an incentive for growth over bordering states. This bill also adds a new project threshold requirement that a private project by a developer must be a minimum of $2 million to qualify for the investment reimbursement structure of the Act. And with that, Mr. Chairman, I stand for questions. I do have someone here to speak on this if there are any technical questions.
Thank you, Chair Lady. You've heard the explanation of the amendment. Is there any questions or comments by the committee? Chairman Crawford, you're recognized.
Thank
on
you,
the
sir.
amendment.
I just wanted to congratulate the sponsor on what a great bill this is. It's just absolutely great. And I appreciate all your hard work that you've done on it because it touches so many different people in our area. Thank you.
Well, thank you for that.
Okay.
I agree.
Is there objection to the question? We're voting on amendment 14700. All in favor, say aye. Opposed, say no. The ayes prevail. We're back on House Bill 725 as amended. Is there any other questions or comments? Is there objection to the question? Hearing none. We are voting on House Bill 725 as amended. Madam Clerk, open the voting board, please. Every member cast their vote. Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 6 ayes and 0 noes.
The ayes prevail. House Bill 725 is amended, moves to the next available county, state, and local government.
Thank you, Mr. Chairman and committee.
Without objection, we'll move back to item 5 on today's calendar, and it is House Bill 2552. We have a motion and a second. Chairman Williams, you're recognized. Do you have an amendment on this bill?
Yes, I do. 011246.
We have just a moment.
I have a unbelievable administrative staff here. Drafting code 014771.
Amendments 14771. Is there a motion? Motion. We have a motion and a second. You're recognized. Does it rewrite the bill, Mr. Chairman?
I believe it does, sir.
So you're recognized on the amendment.
Thank you. This bill is an administration bill that continues on Governor Lee's efforts as it relates to streamline the construction process and help to improve overall affordability to particularly housing, but all construction projects by cutting and eliminating red tape. This bill starts a 30-day shot clock that requires the approval or denial decisions within 30 business days. If a deadline is missed, the application is automatically deemed approved. Unlike voluntary guidelines, this creates real consequences for those departments that choose not to move expediently. It also has a 2-strike maximum, which limits deficiency reports to 2 rounds. Inspectors must consolidate feedback upfront, and a third report triggers automatic 50% fee refunds, a financial penalty that incentivizes thorough initial review. This happens to me on a regular basis whenever I'm trying to pull permits or to get inspections. Automatic bond release. Upon certified engineer confirmation of completion, government must release the bonds within 30 days. There are some members that are experiencing those bonds being held sometimes as long as 3 years. This would require, once that certificate of occupancy is complete, that they would release the bonds. And finally, it prohibits requiring developers to fund off-site projects that are not related to the project itself. Sometimes someone might require a widening of a road 2 miles away in order to get the project completed. That's what the bill does, Chairman. I'm happy to answer any questions. That's what the bill does as amended. Happy to answer any questions.
Thank you, Mr. Sponsor. We are on the amendment that makes the bill. Vice Chairman Wright, you're recognized on the amendment.
Thank you, Mr. Chairman. Chairman Williams, the time from submission to there's got to be a response from the governmental organization, is that now 60 days?
I think it really depends on the municipality, but generally speaking, it's 60 days. Yes.
The bill is
Chairman.
amended is going to say, I'm sorry.
I'll have to check with you.
You're recognized. Take a moment, Mr. Sponsor, and check that time period.
It says two sections in 751-2204. It's 60 days for of the submission to approve a development application, or within 30 days to provide the developer with a written report. So it's both.
Thank you,
Vice
Mr.
Chairman Wright, you're recognized.
Thank you, Mr. Chairman.
Representative Mitchell, you're recognized on the amendment.
Yeah, thank you, Mr. Chairman. I agree with you. 2 miles away from the project, that's one thing. But when you say off-site of the project, if the adjoining road, if they're requiring a turning lane or they're requiring a signal or sidewalks, would that still be permissible in your legislation?
Chairman Williams.
Thank you. It still is, it's adjacent to, and there was appropriate traffic study. Generally speaking, what you're describing would be a traffic study, or the planning and zoning would require the sidewalks on their property. What this would prohibit is from them going adjacent to the property to require them to make improvements that are not related to that project at all.
Okay.
Representative Mitchell. Chairman Crawford, you're recognized.
Thank you, Mr. Chairman. I don't know if this is on the amendment, but it says as amended. So I'm just looking at the expenditures versus the revenue. And I see that state expenditures is going to run about 21 million. But when I look at the local government, it says FY 45-46, and it's got 21,412,800 for our locals, which is great, but I'm confused a little bit on the permissive above it. Is that going to be broke down between the different, everybody that uses and uses this and does the permissive side?
Chairman Williams.
Thank you. I don't have the amended fiscal note in the packet that was provided to me, but generally speaking, based on my experience in finance, if it's permissive, then there's not assigned a value to it because it's up to the local to determine that, or the specifics of that local government.
Chairman Crawford.
Okay, I that's the way I normally see it too, but this actually had the number and I was kind of confused. So thank you.
Chairman
Thank you.
Williams, anything else?
No,
Any
sir.
other questions? We're voting on amendment 14771. Objection to question? Hearing none. All in favor of the amendment, say aye. Aye. Those say no. The ayes prevail. We're back on House Bill 2552 as amended. Is there any other questions or comments for the sponsor? Is there objection to the question? Hearing, seeing none, we are now voting on House Bill 2552 as amended. Madam Clerk, open the voting board. Members, will you please cast your vote? Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 5 ayes and 2 noes.
The ayes prevail. House Bill 2552 is amended, moves next available calendar, state and local government.
Thank you, Chairman, members.
You're welcome. That brings us back to item 9, House Bill 2495 by Chairman Farmer. We'll pause for one moment. Sergeant at Arms, would you check the clerk's office for us, please? Chairman Butler, for what purpose?
Thank you, Mr. Chairman. I wonder if we can turn the air conditioner down in here. It seems to be a little hot.
We had the same request last Wednesday. Chairman Farmer, you're recognized on House Bill 24, no, you're not. Next item is 2495 by Chairman Farmer. Is there a motion? We have a motion, a second. Now you're before us and you're recognized on House Bill 2495. Do you have an amendment?
I do.
And it is?
I have, one moment, please. Okay, it should be 14210.
It is.
All right.
We have a motion. Do we have a second? Second. We have a motion and a second on amendment 14210, and you're recognized on the amendment.
Well, thank you, Mr. Chairman. I wasn't so lucky in Chairman Grill's committee over there, so I'm glad I got this one right. What this does, Mr. Chair Committee, there was some legislation passed in 2011. I talked about certain developments, private communities and places that have, tennis courts and some things that are swim pools and stuff like that, and stuff that's provided for the guests that occupy those properties. This bill would just simply clarify that club memberships in these communities are part of the homeownership package. That's all it does. It just kind of tidies up that 2011 statute there. It was a little broad. We just want to make it clear that these club memberships in these communities are part of the home ownership packages initially when they're purchased.
Okay. The amendment 14210 rewrites the bill.
Yes.
Is there questions or comments for the sponsor? Hearing or seeing none, is there objection to the question? We are voting on amendment 14210. All in favor say aye. Aye. Opposed say no. The ayes prevail. We're back on House Bill 2495 as amended. Is there any other questions or comments? Sponsored, any other comments?
No, Mr. Chair.
Is there objection to the question? Hearing no objection, we're voting on House Bill 2495 as amended. Madam Clerk, open the voting rolls. Will members please cast their vote? Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 7 ayes and 0 noes.
The ayes prevail. House Bill 2495 is amended, moves next available calendar, state and local government.
Thank you.
Item 10 by Chairman Farmer. We have a motion and a second on House Bill 2496. Do you have an amendment on this bill?
I do. 14724.
That is correct. Is there a motion? Motion and a second. Chairman Farmer, does it rewrite the bill?
It does.
You are recognized on the amendment.
Thank you. Members, what this amendment does, it would allow for, if you all have driven out East Tennessee, 407 exit where the Smoky Stadium's sitting there, been sitting empty for a little bit since they moved over to Knoxville. This would allow for development of that property. It's going to be amazing. We've got some folks who want to come in, develop it. And what this bill does would create a new facility definition to kind of match what this legislation would just be dealing with that stadium property only, and would allow a supplemental tax. It would allow for a local supplemental tax up to 5% on admissions, lodging, restaurants, entertainment, and amusement activities. And the revenue would be dedicated solely to redevelopment costs and infrastructure. So we're trying to develop that property, and the developers that are coming in, we're trying to help them or I think we need to help them, frankly, because the state helped that stadium to the tune of about $15 million to get moved over to Knoxville. So at this point in time, we're just asking that the state forbear collection on certain taxes just for a period of time up until we recollect that back to allow these folks to develop that property. It's going to create a lot of sales tax revenue that we'll send down to Nashville. It'll go all over the state. So that's just a 10,000-foot view of what this bill does.
You've heard the explanation of the amendment. Is there questions or comments to the sponsor on the amendment? Is there objection to the question? Hearing none, we're voting on Amendment 14724. All in favor say aye. Opposed say no. The ayes prevail. We're back on House Bill 2496 as amended. Is there any other questions or comments? Is there objection to the question? Hearing none, Madam Clerk, open the voting board. We're voting on House Bill 2496 as amended. May every member cast your vote. Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 6 ayes and 1 present not voting.
The ayes prevail. House Bill 2496 as amended moves next available counter state and local government.
Thank you, Mr. Chair, Committee.
Item 11, House Bill 890 by Chairman Todd. Is there a motion? We have a motion and a second on House Bill 890. Chairman Todd, you're recognized on the bill. Do you have an amendment, sir?
Double check. I'm on drafting code 14338.
We have a motion. Do I hear a second? I have a motion and a second on Amendment 14338, and you're recognized on the amendment.
Thank you, sir. This makes the bill, and the bill makes it clear that municipalities do not have the authority under state law to forgive county taxes, and has 2 key takeaways. If a corporation negotiates payments in lieu of taxes that result in a proposed agreement that could result in the abatement, reduction, or non-payment of taxes, the corporation shall not enter into any agreement until the governing bodies of both city and county approve the terms of the agreement by adopting a resolution at a public meeting. Second, any agreement that affects city and county revenues prior to gaining the approval of both governing bodies shall be considered void.
You've heard the explanation of the amendment. Or questions, comments? Is there objection to the question? Hearing none, we're voting on Amendment 14338. All in favor say aye. Opposed say no. The ayes prevail. Now we're back on House Bill 890 as amended. Is there any further questions? Chairman Crawford, you're recognized.
Thank you, Mr. Chairman. I have one question, and the best way I can probably answer it is give you a situation. If a privately owned company is sitting in the city limits, and let's say the city owes them, I'm just making a number up, $500,000, and the county also owes them $500,000, would your bill keep them from having to be paid? Or would it allow, it wouldn't change anything when it comes to that?
Chairman Todd.
Thank you, Mr. Chairman, and I appreciate the opportunity to clarify. I'm going to give you an example of what this does.
Yeah.
So if the town of Paris decided to offer a pilot to somebody in the industry to come in, what's happening now in some places, and I was very surprised to learn this, anybody would even think this is right, but Paris could negotiate a deal that would abate not only the city taxes, but also the county taxes. And the county doesn't even know about it until they send a tax bill out next year and it comes back saying, we don't owe this and here's our document. I don't know who thought that was right, but this says you can't do that. You can't, you got to have an agreement between the city and the county, both of you, to abate the taxes for both municipality and county.
Chairman Crawford.
Thank you. Thank you, Mr. Chairman.
Any other questions? Any other comments? Is there objection to the question? Hearing none, we're voting on House Bill 890 as amended. Madam Clerk, open the voting board, please. Will every member cast their vote? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 6 ayes and 0 noes.
The ayes prevail. House Bill 890 as amended moves next available counter state and local government.
Thank you.
Brings us to item 12 on today's calendar, House Bill 2069 by Chairman Todd. Is there a motion? Is there a second? We have a motion and a second on House Bill 2069. You are recognized, and I believe you do have an amendment.
I have drafting code 15064.
Is there a motion on the amendment? We have a motion and a second on the amendment. It's properly before us. Chairman Todd, you're recognized on the amendment.
Thank you, Mr. Chairman. This legislation clarifies that the ancient common law concept of public nuisance cannot be manipulated or misused to attempt to regulate industries and advance social and policy priorities in the courtroom. It also makes sure that Tennessee's Attorney General directs the litigation and litigation strategy of the state without interference from plaintiffs' lawyers hired by political subdivisions to bring lawsuits over matters of statewide and nationwide concern. In Tennessee, policy decisions belong to the people and their elected representatives, not to whoever files the most creative lawsuit and stands to profit from it. Further, litigation decisions that will impact every Tennessee citizen should be made by the public official appointed to do so, and that is the Attorney General. This bill does not eliminate the public nuisance cause of action. It simply ensures that it is applied correctly and in a manner that will help Tennesseans. Nor does this legislation block political subdivisions from overseeing matters of local concern. It simply puts logical checks in place to protect against interference with the Attorney General in carrying out his duties. This legislation stops abuse, preserves enforcement, and restores legislative authority.
You've heard the explanation of the amendment. We do have a speaker who would like to speak to this. Is Roger Boney is here. And at this point, we will go out of session. Please have a seat. There should be a button to turn on your mic. You're up. And you have 3 minutes. You'll say your name for the record and who you represent.
Thank you, Chairman Moon. My name is Roger Gibboni, and I come before the subcommittee today on behalf of the U.S. Chamber of Commerce's Institute for Legal Reform. First of all, ILR greatly appreciates Representative Todd for crafting and introducing this important reform. We echo the comments of Representative Todd. HB 2069 is good government legislation. It ensures transparency, appropriately affords deference to Tennessee's Attorney General and his sovereign authorities, and brings Tennessee code more closely in line with the rule of law and fundamental principles of fairness. It does this in 2 important ways. First, HB 2069 ensures that before Tennessee political subdivisions engage with private law firms on a contingency fee basis, the Attorney General has an opportunity to review those contracts and confirm, 1, that they are legitimate, and 2, that the proposed litigation would not interfere or undermine the state's own litigation or enforcement priorities. This mechanism will ensure that Tennessee cities, counties, and other political subdivisions, which only represent and will only prioritize the interests of a relatively small portion of the state and its citizens, cannot attempt to litigate matters of statewide or national concern without the Attorney General's approval. For all other litigation brought by political subdivisions, this legislation will have no effect. Critically, this safeguard will also protect against Tennessee municipalities knowingly or unknowingly being used as vehicles for policy-oriented litigation by activist organizations and profit-motivated litigation by private plaintiffs' lawyers. To be clear, this reform is not a new concept in Tennessee law and is entirely consistent with the current code. Title 8, Chapter 6, Part 1 of the code is unequivocal in stating that it is among the Attorney General's duties to direct all civil litigated matters in which the state of Tennessee or instrumentality of the state may be interested. HB 2069 will provide a critical and necessary tool for the Attorney General to effectively carry out those duties. As Representative Todd said, this will also address abuses of the public nuisance cause of action, which are one of the most commonly used causes of action by municipal plaintiffs. Real quickly, let me be very clear about what this legislation will not do. This legislation will in no way prevent or hinder local governments from hiring private attorneys to assist with litigating matters of local concern, nor will it have any impact on those localities' use of counsel paid through traditional financial arrangements. HB 2069 is relatively simple. It provides a healthy dose of transparency in the process of political subdivisions hiring private plaintiffs' lawyers and will ensure that Tennessee law is clear, predictable, and fair. For these reasons, ILR respectively urges this subcommittee to pass HB 2069. I welcome any questions.
Thank you for your testimony and being with us today. Representative Dixie, you're recognized for a question.
Thank you, Mr. Chairman. Thank you for being here. Quick question for you. By your testimony, you stated that already in code that the AG has this authority. So if he has this authority, then why do we need this bill?
Mr. Boney.
Yeah, absolutely. It's a great question. The code states that the Attorney General has the duty to oversee all state litigation in matters of statewide or national concern. The reality is the Attorney General doesn't currently have a mechanism to effectuate that. So this would simply put in place a mechanism for political subdivisions to go to the Attorney General before suing.
Representative Dixie.
So thank you for that. And I understand that. And that's what gives me a little heartburn because the AG is supposed to be the attorney for the entire state. But for over these last few years, that position has become political. And that's what gives me pause about this because it depends on what's going on and who ear he has to whether he chooses to represent or approve and it gives him a little bit too much authority. And
Representative Dixie, I believe that's a great question for the sponsor.
Okay.
Representative Mitchell, I believe you have a question.
Yeah, thank you, Mr. Chairman. You know, I'm kind of in the belief less is more in our TCA code. So I like to have a reason why we're doing this. Can you give me an instance that occurred in the state of Tennessee where you think this would have corrected that situation?
Mr. Jaboni.
Sure. There's been several instances throughout the country, including here in Tennessee, where cities and counties have attempted to sue auto manufacturers for making their cars too easy to steal. Those are the kind of matters that localities may have an interest, but it may be something that the state is better addressing on the statewide level and can more effectively and efficiently negotiate terms of settlement, find recourse for municipalities or certain citizens. But when each municipality throughout the state is doing it, it adds tremendous complexity and becomes, almost impossible to settle at some points.
Representative Mitchell.
So there has been a lawsuit like that filed by a city in Tennessee?
Mr. Boney.
The city of Nashville joined the Hyundai Kia lawsuit.
Representative Mitchell. Good. Any other questions? Thank you very much for your testimony. We'll go back into session, and we're on Amendment 15064. Any other questions for the sponsor? We're on the amendment. We're on the amendment. Is there objection to the question? Hearing no objection, we're voting on Amendment 15064. All in favor, say aye. Opposed, say no. The ayes prevail. The ayes prevail. And we're back. We're back on the bill as amended. And Representative Mitchell, you're recognized.
Thank you, sir. To the sponsor, over the last 4 or 5 years, City of Nashville has been quite successful in the court system, beating back unconstitutional legislation that's been passed down here. If your law would have been in effect prior, would it have required the City of Nashville to ask the Attorney General permission to be able to sue in any of the following circumstances? Reducing the size of the Metro Council. 2, the unlawful takeover of our airport. 3, the unlawful takeover of our Metro Sports Authority. Or let's see, what's some of the other 8 or 10 that we've beat y'all at? But those three would be
Chairman
good enough.
Todd, you recognize?
Well, who is we and beat y'all? Who are we and y'all in that statement?
Representative Mitchell.
He needs an answer. Well, us are the people of Davidson County who are paying most of the bills in this state from our taxes. And y'all are the ones who are trying to harm the economic engine of the state of Tennessee, Nashville, Tennessee.
Chairman Todd.
Thank you, sir. It's been a while since I had a civics lesson, but the best I remember, cities and counties are subdivisions of the state government. Wouldn't exist if the state didn't want them to exist. So as subdivisions, they are subject to the laws of the state. And that's all this is about.
Representative Dixie, you're recognized.
I guess.
He never answered.
Representative Dixie, you've sought the floor. You're recognized.
Yeah, I was going to say, could you possibly answer his question?
Chairman Todd, you're
Thank you, Mr.
recognized.
Chairman. After all the political statements, I probably need to have him restate the question, just to make sure I don't get it wrong.
Representative Mitchell, you're recognized.
In 3 instances where unlawful, unconstitutional legislation was passed by this General Assembly, the city of Nashville sued the state in court regarding reducing the size of the Metro Council, the unlawful takeover of our airport, and the unlawful takeover of our sports authority. If your law that you're proposing right now was in existence, would the city of Nashville had to have asked permission to sue?
Chairman Todd, you're recognized.
Thank you. I do not believe so. I don't think anything in the opening statement had anything to do with a city suing the state. This is about cities suing companies, suing other entities. So I don't believe that would affect that.
Any other questions? Any other comments? Is there objection to the question? Hearing, seeing none, we're voting on House Bill 2069 as amended. Madam Clerk, open the voting board. Let every member please cast their vote. Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 5 ayes and 2 noes.
The ayes prevail. House Bill 2069 as amended moves to the next available calendar, state and local government.
Mr. Chairman, I have one on the addendum, and I didn't know if you want to take that now or later.
What item number is it, Chairman Todd?
I don't have a calendar in front of me. It's House Bill 889.
Say again.
Totally up to you, sir.
It's number 49 on the amended calendar, and we will probably take that up next week, Chairman Todd. Thank you, though, for your question. Next item on today's calendar is item 13, House Bill 2386 by Chairman Vaughn. Without objection, I'd like to roll this to the heel. Hearing no objection, House Bill 2386 is rolled to the heel. Item 14, House Bill 2587 by Chairman Vaughn. Without objection, House Bill 2589 will be rolled to the heel. Hearing no objection, 2587 is rolled to the heel. Excuse me, did I say 89? Excuse me, the record should say House Bill 2587 is rolled to the heel, item 14. Brings us to item 15, House Bill 2592 by Chairman Vaughn. Without objection, Chairman Crawford, you're recognized.
Thank you. I'm sorry, Mr. Chairman, but I can't remember exactly. We can't take up a bill without the sponsor. We can't take any action on a bill without the sponsor being here, correct?
We can roll it to the heel. We
Okay.
can roll it to the heel of the calendar.
But we can't pull
We
it up.
cannot bring it up to,
Okay.
For consideration. So
That's what I was thinking.
yes, sir. So we're on item 15, House Bill 2592 by Chairman Vaughn. Without objection, we'll roll to the heel. Hearing no objection, 2592 is rolled to the heel. Item number 16, House Bill 2607 by Chairman Halsey. The sponsor has asked that this bill be taken off notice. Is there objection? Hearing no objection, 2607 is off notice. Item 17, House Bill 2261 by Chairman Martin. We have a motion and a second on House Bill 2261. You're recognized on the bill, and do you have an amendment?
Yes, sir, I do, Chairman. It's 015389, 015389.
We have a motion and a second on Amendment 15389. You're recognized on the amendment. Does it rewrite the bill?
It does.
You're recognized.
Thank you, Chairman and Committee. House Bill 2261 seeks to add certain requirements when recording notices, affidavits, memoranda of abstract of agreements to purchase real estate. Real estate fraud is a prevalent issue not only in our state, but also across the country. And this bill would require that both the buyer and the seller sign these documents to be eligible for recording. By adding this extra layer of transparency, this bill helps ensure the legitimacy of these agreements, further protecting against fraudulent activity. This bill also requires that both signatures be authenticated by a notary or a witness. And finally, the amendment clarifies which documents this applies to. I want to thank the hard work put in by the Registers Association, the Land Title Association, and the Tennessee Bar Association on this amended language. And with that, Mr. Chairman of the committee, I stand ready for questions.
Is there questions on the amendment? Seeing or hearing none, or is there objection to the question? We are voting on Amendment 15389. All in favor, say aye. Opposed, say no. The amendment goes on the bill. We're back on Bill 2261 as amended. Is there any other questions or comments? Is there objection to the question? Hearing none, we are voting on House Bill 2261 as amended. Madam Clerk, open the voting board. Members, please cast their vote. Members, please cast their vote. Madam Clerk, take the vote.
Mr. Chairman, you have 7 ayes and 0 noes.
The ayes prevail. House Bill 2261 moves to next available calendar. And Chairman, I owe you an apology.
It's all good.
Thank you,
Thank
sir.
you.
Next item is item 18 on House Bill 2306. The sponsor has asked that this be rolled to the heel. Is there objection? Hearing no objection, House Bill 2306 is rolled to the heel. Next item on today's calendar is item 19, House Bill 2031 by Chairman Faison. And the sponsors asked that this be taken off notice. Is there objection? Hearing no objection, House Bill 2031 is off notice. The next item on today's calendar is item 20, House Bill 2478 by Parkinson. Sponsors just requested that House Bill 2478 be rolled to the heel. Is there objection? Hearing no objection, House Bill 2478 is rolled to the heel. Next item on today's calendar is House Bill 21, House Bill 298 by Representative Bain. There's a motion. Is there a second? Fails for lack of a second. Next item on today's calendar is item 22 by Representative Gant. Representative Gant, you're recognized on House Bill 162. We have a motion. Do we have a second? We have a motion and a second. Do you have an amendment on your bill, Representative Gant?
Mr. Chairman, let's see. I think the amendment writes the bill, if I'm not mistaken.
14886.
The one I've got is 14766, which is the amendment that writes the bill.
Just a moment. We have from the clerk's office 14886. We're checking. Just a moment. This has been filed by Chairman Crawford. So Chairman Crawford, is there a motion on 14886? We have a motion and a second on Chairman Crawford's amendment, 14886. You're recognized, Chairman Crawford.
Give me just a second to find it.
Just a moment. This is also known as a cooling off period.
Okay.
Chairman Crawford, you're recognized.
All right, House Amendment number 1. It's a 014886. This rewrites the bill, authorizes a county or municipality to pay a property tax refund to eligible taxpayers through annual installments, applied as credit against the taxpayer's future property tax obligations pursuant to the written settlement agreement entered into between the two taxing entities, and the taxpayer repeals the act on June 30th, 2041.
You've heard the explanation of the amendment. Does anyone have questions? Seeing and hearing no question, we're voting on Amendment 14886. All in favor say aye.
Aye.
Opposed say no. The ayes prevail. We're back on House Bill 162 as amended. You're recognized, Representative Gant.
Mr. Chairman, we've got two bills that are very similar. I'm the next bill after this, so I got a little bit before you, but Representative Crawford is the one actually running this legislation. So
The prime co-sponsor I have first on the list is
I
Representative
understand.
Gant, and we appreciate you coming and presenting this bill as amended. And the other issue is Chairman Crawford has not signed on the bill, but he could amend the bill. So that's why you're before us. Is there any other questions for the sponsor on House Bill 162 as amended? Seeing none, hearing none, we're now voting on House Bill 162 as amended. Madam Clerk, open the voting board. Will every member please cast their vote? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 7 ayes and 0 noes.
The ayes prevail. House Bill 162 as amended moves to the next available calendar, state and local government. Now, item 23, House Bill 1762 by Representative Gant. We have a motion and a second. Bill's properly before us. Do you have an amendment?
the amendment that I have, Mr. Chairman, is the one that we had earlier.
14766.
14766, that is correct.
Is there a motion? We have a motion on amendment 14766, and you're recognized on the amendment.
Thank you, Mr. Chairman. And I tell you, your committee redefines the seat of being in the hot seat. It is like 100 degrees in here.
Thank you for your comment, but please be on the bill, sir.
So, Chairman and committee, I rise today to present House Bill 1792. It's a straightforward but essential consumer protection initiative designed to safeguard Tennessee families from deed fraud and the economic harm it creates. Across our state, we have seen an increase in fraudulent and poorly drafted deeds, leaving Tennesseans vulnerable to financial loss, title defects, and property disputes they never saw coming. Our General Assembly has formally recognized this growing problem and the economic damage it causes to innocent property owners and prospective buyers. This bill addresses that problem head-on by requiring that deeds prepared only by trained professionals, licensed Tennessee attorneys, licensed title insurance agents, or by actual property owner or someone legally authorized to act on their behalf. These are the people who understand the legal significance of these documents and know how to prepare them correctly. We also strengthen the verification process by requiring a sworn declaration or notarized affidavit stating exactly who prepared the deed and confirming that they are legally authorized to do so. This simple safeguard gives our county registers a powerful tool to screen out fraudulent and unauthorized filings before they can harm our citizens. Importantly, the bill preserves common sense exceptions. Government filed deeds and deeds prepared by financial institutions with a legitimate interest in the property are not affected, ensuring that ordinary mortgage and government transactions continue smoothly. Colleagues, this is not a complicated bill. It is a protect the consumer bill, a protect the homeowner bill, and above all, a protect the public welfare bill. It raises the standard of property transfers in Tennessee without burdening legitimate actors, and it helps ensure that one of the most significant financial transactions a family will ever make, buying or selling a home, is secure, transparent, and trustworthy. I respectfully ask for your support of this and for your commitment to protecting Tennessee property owners from the fraud that we are seeing run rampant across Tennessee and the United States. And Tennessee always leads, Mr. Chairman and committee, and this is one way that we are taking that first step to protect consumers. And I will try to do my best to answer any questions that y'all may have.
We're on the amendment. Representative Dixie, you're recognized.
Quick question. With this bill or this amendment to this bill, would it change the way that title insurance companies operate now? Because it says to be licensed by the state, and sometimes they have their, I guess, their person in their office that may be a notary public, a public notary. That's what I'm trying to say, a public notary that actually completes the documents and stamps things. Will they have to sign, would the actual owner of the company have to sign off on that as well, or would that change any?
Representative Gann.
Yeah, thank you, Chairman. This is only referencing the selling of the home, and it does not reference anything about the title insurance.
Representative Dixie.
Oh, because I was saying, when it looks, it says it has to be prepared by a licensed attorney in this state, a title insurance agent in this state, and the owner of the real property being transferred. So that's why I was asking.
Right, that's
Representative Gann.
Sorry, that's the recognized person that can transfer or have the affidavit drawn up is through a title agent or an attorney.
Representative Dixie. Any other comments or questions? Vice Chairman Wright, you're recognized on the amendment, sir.
Thank you, Mr. Chairman. So I thought I had a straightforward question. As I read this, the paper can be prepared by an attorney.
Representative Gann.
No, or you said a title insurance person or the current owner. That's where I was headed. Can the current owner prepare the paper?
Representative Gann.
That is correct.
Vice Chairman Wright.
Thank you, Mr. Chairman. And the current owner then has to sign an affidavit to this effect also.
Representative Gann.
That is correct also.
Thank you, Mr. Chairman.
Any other question? Good question. Is there any other questions? Comments? Is there objection to the question? All in favor of the amendment 14766, say aye. Opposed, say no. The ayes prevail. We're back on House Bill 1762 as amended. Is there any other questions, comments? Is there objection to the question? Hearing none, we're voting on House Bill 1762 as amended. Madam Clerk, open the voting rolls. Every member cast their vote. Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 7 ayes and 0 noes.
The ayes prevail. House Bill 1762 as amended moves to the next available calendar, state and local government.
Thank you, Chairman and committee.
Item 24, House Bill 1670 by Chairman Rudd. Is there a motion? There's a motion and a second. You're recognized on House Bill 1670. Do you have an amendment?
Yes, sir. I have 13144, makes the bill.
Is there a motion? We have a motion and a second on Amendment 13144. You're recognized on the amendment.
Thank you, Mr. Chairman. This legislation reaffirms the longstanding constitutional tax policy and protects Tennessee homeowners and renters from crippling property tax increases. For more than 50 years, the Tennessee has maintained a clear, consistent standards of how residential property is assessed under Article 2, Section 28 of the Tennessee Constitution. single-family homes, whether owner-occupied or rented, have been treated as residential property. And that is clearly defined in the 1971 convention, Constitutional Convention that established this when they discussed the matter. The Tennessee Constitution requires residential property to be assessed at a 25% of value, provided that the property does not contain two or more rental units, which is defined as industrial or commercial under the law. That clarity and that common sense has provided stability to homeowners, renters, and local governments alike for a half a century. In a handful of counties, I believe it's approximately 6, county property assessors have begun reclassifying single-family rental homes as commercial entities, going from 25 to 60% tax rate. And this shift is not grounded in any new statute, constitutional amendment, or legislative action. Instead, it stems from a misapplication of a narrow court ruling in Sevier County, Tennessee versus the Tennessee State Board of Equalization. And that case specifically addressed that timeshares and multifamily units are one property and not single-family residences. This reclassification scheme translates into property tax increases of approximately $1,200 per single-family home and townhome. The increase per year. Per month. The broad impacts of reclassification effort include higher housing costs, fewer available rental homes, economic instability, erosion of property rights, taxation without representation. The reclassification also forces local government to repeatedly revalue the same property when a homeowner decides to rent it out. It triggers an avalanche of appeals, challenging value methods, and creating costly legal and administrative burdens on the counties and property owners. This legislation does not apply to short-term rentals or condominiums. And in closing, Mr. Chairman, I can get to my closing second page. HB 1670 reaffirms the constitutional definition of a residence and clarifies that single-family homes and townhomes shall be classified as a residential rate regardless of rental status, as has been done for the past 52 years. And that is the amendment on the bill.
Thank you, Mr. Sponsor. At this time, we do have 2 people signed up to give testimony, so we shall go out of session and hear the 2 people who have come to testify. Walter Blanks, if you'll come forward, please, and introduce yourself to the committee. You're recognized for 3 minutes.
Thank you, Mr. Chairman and members of the committee. My name is Walter Blanks Jr. And actually, before I begin, I have to give a special shout out to my son. Today is his birthday and his second birthday, and I'm here, which I'm happy to be, and which is funny because last year when he turned 1, we were in DC because I was testifying before Congress. So I'm really happy to be a little bit closer to home. I am currently the co-founder and executive director of the Legacy Society, and I'm here today in support of HB 1617. And I'm here today not only as an advocate, but also someone who has experienced Tennessee's housing market from both sides, as a renter and as a small landlord. Currently, I rent here in Nashville. As of 48 hours ago, my wife and I bought our first home, so this will be our last month renting for the foreseeable future. And we also own a single-family home that we rent out to a tenant. This perspective allows me to understand firsthand how changes in property tax policy can affect both renters and property owners. For more than 50 years, as Representative stated, Tennessee has treated single-family homes as residential properties under our Constitution, whether the owner lives there or rents it out. And that standard has created a lot of stability for homeowners, renters, and communities across the entire state. Now, recently, we've seen some county assessors begin to reclassify those as commercial properties. And if that approach spreads, it will dramatically raise property taxes on said homes. And when property taxes go up, so does rent. It's that simple. And as a landlord, I really want to keep rent affordable for my tenants. But if my property taxes suddenly increases, that forces me to make difficult decisions either for my own family or for the tenant. And I know exactly who this impacts first. It's tenants, renters. Renters can be young professionals trying to get their start, working families trying to save for a first home like me and my wife, seniors living on fixed incomes, and folks who have just moved to town. And these people are the ones who will face higher rents if single-family homes are treated as commercial investments rather than actual homes. And we all know that taxes are ultimately passed along to the consumer. HB 1617 provides a clear and simple solution. It reaffirms the longstanding constitutional standard that single-family homes should be assessed as residential property. Passing HB 1670 will help protect renters, preserve affordability, and ensure that Tennessee remains a place where people can live, work, and build their futures. Thank you for your time and your consideration on this important matter, and I welcome any questions you may have.
Thank you for your testimony. Next on the list is Will Denami. If you'll come forward, please. Are you going to speak? Yeah. Come up and for the record, identify yourself. Mr. Denami, you're recognized for 3 minutes.
Thank you, Mr. Chairman and members of the committee. My name is Will Denami. I'm here on behalf of the assessors of property who oppose this legislation. I ask you to vote no. And while I appreciate my friend, the chairman, Mr. Rudd, very much, I want to just put a couple of facts on the record here. On August 3rd, 1972, the voters of Tennessee voted 73.77% in favor of Article 2, Section 28. That provision of the Constitution is our modern property tax system. It was taken to court in Memphis v. Snow, and I'm going to read from a 1998 Supreme Court case, and these are just the words of the Supreme Court. The court in Snow v. City of Memphis found that the purpose and objective of the Article 2, Section 28 is to tax income-producing property at a higher rate than owner-occupied residences and farms. That's from the Supreme Court, 1998, and they're following the Supreme Court from 1975. This is not new. I've got a case right here from Knox County, 2014, 2015. This is 60 single-family rental homes. This is not new. This has a $55 million fiscal note on it. And as you all know, when you give a tax break of $55 million, unless you identify teachers and sheriff's deputies to cut, then that money is still going to have to be paid for maintenance of effort. That means you're going to have to raise taxes $55 million in order to pay for this tax cut. So with that, I'll answer any questions you have.
Thank you for your testimony. Is there any questions for the people before us? Representative Butler, you're recognized.
Thank you, Mr. Chairman. I guess my question is more for Will Denami. You mentioned that these are places of residence. So if you own a timeshare, does the person that not own the timeshare spend part of the year in that residence?
Mr. Denami.
So the timeshare was a different bill. That was House Bill 889. This one, 1670, is on different rental property. So these are two different issues. But timeshares was a separate case, and that's not what I'm quoting here. This is about rental property, so they're different. But yes, timeshares are also commercial.
Representative Butler.
I'm good.
Anyone else? Thank you very much, both of you, for coming to testify today. We will now go back into session. Chairman Rudd, you're recognized on the amendment.
Thank you, Mr. Chairman. He is in fact incorrect. The 1975 decision reaffirmed the Constitutional Convention of 71, which clearly stated in the minutes of the meeting, which I have on my desk, the book from the library upstairs, and it's totally printed out, which I'll be happy to send to you. The 98 decision also was about timeshares, and it reaffirmed what timeshares were defined as. The few counties that are doing this are clearly in error, and also the $55 million fiscal note that he's quoting is the old bill, and the new bill was provided false information. I talked to Mr. Savick. He hasn't issued it to me. I don't know if you have it, but they were provided false information. That fiscal note still includes timeshares and condominiums. When he took that out, it reduced it to around 5.5 to 6 million. And that is money that has been illegally collected since it's violating the Constitution.
Okay, you've heard the explanation. Is there any other questions about the amendment? Vice Chairman Wright, you're recognized.
Thank you, Mr. Chairman. I'm just going to make a comment. I'm not asking a question. On this particular bill, it's about property tax. There must be 20 or at least 18 property tax bills that are floating around about REITs and other things that have been mentioned just now. So to make sure that, since I cannot establish what I think to be a principle involved in these property tax discussions right now, it'll clear my heartburn if the heartburn's going to be on the floor of the House. So I'll support this bill.
To the sponsor, any comments?
Well, thank you. This is a good bill. It does reaffirm 52 years of law. There has been no court decision that overturned the intentions and the intent. The intent of the Supreme Court was misrepresented in court. However, like I said, the journal and the minutes to the convention have been found. They have been transcribed. They were upstairs in the library. There's 2 copies. One of them's on my desk. It clearly states what the intentions were of the legislature in 1971 at the convention. There was an amendment on the floor of that convention that tried to include single families as commercial property. It was soundly defeated, 67 to 22, I believe. And they went forward with what they intended. Their comment was to tax single family rentals, which are built as residential property, not built as commercial entities with the rent already built into them, that would be putting an undue burden on Tennessee residents. And with that, Mr. Chairman, that this is simply codifying 52 years of policy, 52 years of law, and it's still in the Constitution. We can't change policy and tax people without legislative approval.
Representative Dixie, you have a question?
I do. Thank you, Mr. Chairman. So my question is that if this bill goes into effect, how will it impact the collection of property taxes? Because there's only really 2 ways that we have revenue in this state: is property tax and sales tax. So in these counties, how would this impact their ability to basically be self-sufficient, or will this damage their budgets at all?
Chairman Rudd.
Well, as far as I know, from what Mr. Savick at Fiscal Review, what we discussed on the phone yesterday morning, and I expected the note to be issued today unless he's found something else. The last time we talked with condominiums and timeshares taken out, it was around $5.5 million. That's statewide. Most of this is not even been implemented, and they haven't collected a tax because they've either been in court, like in Sumner County, and that Sumner County ruling went against the policy that they have. Also, the equalization boards at many of these counties, like even in Rutherford, has been reversing this and throwing it back, saying no, it's unconstitutional. Even my assessor, who was forced to do this, he sent out a letter with all the to all the people and said, in my view, this is unconstitutional. I advise you to appeal.
Representative Dixie.
So I'm sorry, Mr. Chairman. So the impact is very minimal right now. But if this is allowed to go beyond 6 counties and start spreading, it's going to be an unauthorized tax that we legalize here by not taking action to uphold state law.
Representative Dixie, you're good? Any other questions for the sponsor? Is there objection to the question? We're voting on Amendment 13144. All in favor say aye. Aye. Opposed say no. The ayes prevail. Now we're back on House Bill 1670 as amended. Are there any questions to the sponsor? Is there objection to the question? Seeing and hearing none, we're voting on House Bill 1670 as amended. Madam Clerk, open the voting board, please. Members, please cast your vote. Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 4 ayes, 2 noes, and 1 present not voting.
The ayes prevail. House Bill 1670 as amended moves to the next available calendar, state and local government.
Thank you, Chairman. Thank you, committee. I think I can eat supper now. Thank you.
Item number 25, House Bill 2418 by Representative Boyd. Boyd requests that this bill be rolled to the heel. Is there objection? Hearing no objection, House Bill 2418 is rolled to the heel. Item 26, House Bill 2323 by Representative Alexander. Chair Lady Littleton, for what purpose?
I make a motion that we pull up Representative Reedy while we're waiting on Representative Alexander. He's next on the calendar.
Second that.
We'll bump item number 26, one space. Item 27, Representative Reedy,
Thank
you're
you.
recognized on House Bill 1788. You have a motion? Motion. In a second, you're properly before us. Thank you.
Thank you, Mr. Chairman and committee. It's Senator Crow brought me this bill. There is an amendment 14552.
We have a motion and a second on Amendment 14552. You're recognized on the amendment. Does it rewrite the bill?
It just adds to, and there's 2 things that we're doing with this, and with this amendment from Senator Crow, and you'll be interested in knowing, it creates the Senator Frank Nicely National Security and Economic Protection Act, and then it adds prohibited foreign parties to the current list of foreign-controlled entities that are prohibited from acquiring by grant, purchase, devise, or otherwise an interest in non-agriculture land in this state, Mr. Chairman.
Okay, is there questions, comments on Amendment 14552? Representative Mitchell, you're recognized on the amendment.
Yeah, thank you, Mr. Chair. Could you please describe who we're prohibiting from purchasing land?
Chairman Reedy.
Yeah, thank you, Mr. Chairman. Already in code, it lists foreign party-controlled businesses. And so what Senator Crow, in his wisdom in looking at it, they become the prohibited foreign parties. And so what we were finding is in China, especially if you do business in China, that business is halfway owned by the Communist Party. Okay. And I had a constituent that said, well, I've got a business in China. And I said, okay, do you own the property? He said, no. And I said, so you own all the buildings because you built it on the property? He said, that's right. And I said, well, at any time, if China gets tired of you, they're going to kick you off and send you home, and you don't owe anything. And so that's what we're finding out is all of his information he has to share with the Chinese government. And of course, that's where we're coming into prohibited foreign parties. So what we found is okay, I can go a lot deeper and tell you who those prohibited foreign parties
Representative Mitchell.
Let me just ask you, make it simple. So if, let's say we got someone from Honduras who's here trying to become legal, they go out to Houston County, buy 3 acres of land, want to, do gardening and just raise a family there while waiting their citizenship. Would this prohibit them from doing that?
Yeah. Chairman Reedy.
No, sir.
It would not. That the answer is
yes.
It would not.
No, it would not.
Any other questions? Chair Lady Littleton, any questions for the sponsor? Is there objection to the question? Hearing none, we're voting on Amendment 14552. All in favor of the amendment, say aye. Aye. Opposed, say no. The ayes prevail. We're back on the bill 1788 as amended. The chair has a question.
Yes, sir.
In my district, I have a company that has leases, and they are owned by a Chinese company. And there's been efforts to buy that out, but at this time, they're owned by a Chinese company. So what would their status be with this bill?
Currently, the company that you speak of, no, it has no effect on them because of the leases. And the reason they're allowed to be in this country with leases because they are federally regulated. In other words, and we covered this a couple of years ago talking about them, that there's in federal code, the feds are the watchdogs of those companies and watching how they operate. So in other words, their business records, not business records, it's their business structure has to be shared with the federal government. I don't recall who does that, but if any, as they move throughout the year, is updating the federal government. But if they ever totally change, and an example is some investors in Hong Kong, if they ever change that they could be made to divest in the state of Tennessee.
Okay, thank you very much. Is there any other questions is there objection to the question? Hearing or seeing none, we're voting on House Bill 1788 as amended. Madam Clerk, open the voting board, please. Members, please cast your vote. Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 6 ayes and 1 present not voting.
The ayes prevail. House Bill 1788 as amended moves to the next available calendar, state and local government.
Thank you, Chairman of the Committee.
We will now go back to item 26 by Representative Alexander, House Bill 2323. May I hear a motion? Do I hear a second? May I hear a motion and a second? You're recognized on House Bill 2323.
Thank you, Chairman.
And you do have an amendment.
Thank you, committee. Yes, I do. Amendment number 0153. Wait a minute. No, just 1 second. That's not the latest one. Maybe it is.
13789.
Okay. Yes, sir. That's correct.
Is there a motion on Amendment 13789? We have a motion and a second, and you're recognized on the amendment.
Thank you. Boy, you realize you're old.
On the bill, please.
Oh, I'm sorry. When the elevator doesn't work and you've got to run 5 flights of stairs and back. Okay. Thank you, guys, for being patient on me. This is a bill for my county. That is the bottom line. I'm just going to be honest with you. I've done everything I know how to do to make it right. This bill is a good bill because there are municipalities out there that do not have a school system that a municipality can charge a fee for, as long as that fee goes to a school system. But if you don't have a school system and you're a county that is the county seat and you are a county that is a historic district, the oldest town in Tennessee, actually, and you are a county because you don't have a school system, you're going to have a lot of traffic in that town because you're a county seat and you are a historic district which drives tourism. All we're asking for is ability to do a fee because we don't have a school system to do a fee and it go to our infrastructure and our roads. That's all it does.
You've heard the explanation of the amendment that rewrites the bill.
Yes, that is correct.
Vice Chairman Wright, you're recognized on the amendment.
Thank you, Mr. Speaker.
No.
Excuse me. I got an even better one. Thank you, Mayor.
Out of order.
I apologize. We call this a fee, and it's a two-part question. Is it going only into this historic district
That is correct.
of
You're recognized.
sidewalks and streets in what might be referred to as a downtown historic district?
Representative Alexander.
Thank you, Chairman. Yes, that is correct.
Representative Vice Chairman. Right.
Thank you, Mr. Chair. So I've been a member of these committees for 8 years, and we have frequently had things appear before us that would be called impact fees. And the best I think I could categorize this would be for it to be an impact fee. But so that I don't have to have all this heartburn by myself, I'm going to vote to pass this out to the full House.
Thank you, Vice Chairman Wright. Representative Alexander, any comments?
No, sir.
This is very narrowly written.
Yes,
It
sir.
has to be a county seat
County seat.
and a historic
with a
district
historic
without a
district.
LEA.
Without an LEA.
Are we clear? Is there objection to the question? Hearing or seeing none, all in favor of Amendment 13789, say aye.
Aye.
Opposed, say no. The ayes prevail. We're back on House Bill 2323 as amended. Are there any other questions, comments? Is there objection to the question? Hearing none, we are voting on House Bill 2323 as amended. Madam Clerk, open the voting board. Will members please cast their vote? Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 4 ayes and 1 present not voting.
The ayes prevail. House Bill 2323 as amended moves to the next available counter, state and local government.
Thank you, Chairman. Thank you, committee.
We'll now move to item 28, House Bill 1779 by Representative Leatherwood. I do not see the sponsor. Without objection, we'll roll this bill to the heel. Hearing no objection, House Bill 1779 is rolled to the heel. Our next bill is item 29, House Bill 2521 by Representative Vital. Request that this bill be rolled to the hill. Is there objection? Hearing no objection, House Bill 2521 is rolled to the heel. Item 30, didn't think we'd get here. Item 30, House Bill 2314 by Representative Fritz. We have a motion. Do I hear a second? Thank you. Representative Fritz, you're properly before us. House Bill 2314, you're recognized.
Thank you, Mr. Chairman and committee. I have an amendment that makes the bill with drafting code 13847.
We have a motion. Second. We have a motion and a second on amendment 13847. If you'll please explain the amendment.
Yes, sir. Thank you, Mr. Chairman. The first subsection would require that establishments that post a sign at the entrance that states, and these are like live entertainment, adult entertainment establishments. Attention, I quote, attention. By engaging in this type of entertainment, you may be contributing to an increase in domestic assault, rape, sexual assault, and human trafficking. If these establishments lawfully offer sexually oriented materials, including print, video, and other media, the second subsection would apply. They would be required to post a sign at each display of the material that states, a quote, attention, by purchasing, borrowing, or using this pornographic material, you may be contributing to an increase in domestic assault or sexual assault and human trafficking. Why is this needed? Social scientists, psychologists, and medical professionals have been studying the relationship between the use of sexually explicit entertainment and domestic violence, rape, and sexual assault for decades. In 2021, the National Institute of Health published a longitudinal review of these studies and concluded, as expected, exposure to pornography was positively associated with sexual aggression. In 2000, the U.S. Congress investigated the issue of human trafficking and published the following findings as a part of the Trafficking Victims Protection Act of the year 2000. At least 700,000 persons, primarily women and children, are trafficked annually within and across international borders. An estimated 50,000 of these are trafficked into the United States. And I remind my colleagues, these are older numbers. These are from 2000. Secondly, the sex industry has rapidly expanded over decades. It involves the exploitation of persons, primarily women and girls, and involves activities related to prostitution, pornography, sex tourism, and other commercial sexual devices. In 2024, Unbound Now, an organization dedicated to ending human trafficking, estimated that 40.3 million people are now enslaved globally through human trafficking. 79% of these are sexually exploited. This exploitation generates an estimated $6 to $15 billion annually. That means the number of people being trafficked has more than doubled every year for the last 24 years. Women's advocacy groups and those working against human trafficking all agree that one of the best ways to fight human trafficking and domestic and sexual violence against women and children is to reduce the demand for these sexually oriented businesses and materials. By posting signs that this legislation requires, we can increase awareness about the link between this entertainment and the incidents of domestic violence, sexual assault, rape, and human trafficking. And I'll close with this, Mr. Chairman, to attempt to be brief. It's a sad topic to have to bring. It is a real topic to have to bring. And we really took this idea from the warning labels that we have on tobacco and alcohol products today, that if we can make some small improvement by putting these postings up, it's the right thing to do. So with that, Mr. Chairman, I'll stop and ask for y'all's favorable move.
Thank the sponsor. At this time, I'd like to go out of session and refer this to legal. So without objection, we're out of session. Legal, you're recognized. If you'll give your name.
Thank you, Mr. Chairman. Josh Houston, Legal Services. Representative Moon asked me to speak about the constitutionality of this provision or this proposed bill. There is the First Amendment protects the freedom of speech. It also protects against the government requiring a person to speak. So in this instance, I think this may be constitutionally suspect just because it is requiring an entity to make speech that it is not otherwise would have.
While we're out of session with legal, are there any other questions to legal? Okay, we'll go back into session. We're still on the amendment 15401. Is there any other questions? Is there objection to the question? Hearing none, all in favor of amendment 15401, say aye. Opposed, say no. Chair hears a tie. Motion on the amendment fails. We're back on the bill. So we're back on 2314. If the amendment, does the bill
Thank you, Mr.
do
Chairman.
what you want to do?
The amendment is the bill, Mr. Chairman.
Okay. So we're still going to vote on the bill.
Okay.
So
I would
on the board.
Mr. Chairman, I would seek any advice that you have on that. If I would make this statement, I would just offer this: the bill and what it is. If we could keep that alive and modify by passing it, perhaps that's an opportunity. I'm sorry, I could not. I'm horrible at lip reading.
Okay. I will, all right. Thank you so much for that advice. I would just close with this statement, Mr. Chairman. I certainly understand and respect council's advice on this. I think this is one of those things we have exercised these warning labels on other industries, and certainly Tennessee could lead the way. We are one of the, by many estimates, the chief states in human trafficking because of the configuration between Interstate 40 and Interstate 75. And so with your recommendation, Mr. Chairman, I'll take this off notice for now. Before I stop that, will we have another opportunity to put it back on in this session?
We're on the final calendar.
I'll just let y'all vote in it. I'll withdraw that statement.
Or you could roll it to the heel.
I'll make a request to roll to the hill then, Mr. Chairman.
Without objection, hearing no objection, House Bill 2314 is rolled to the heel.
Thank you.
Our next bill is, help me out. Item 31. By Representative Capley. Representative Capley was here earlier. I do not see him. So without objection, we'll roll House Bill 1657 to the heel. Our next item, we'll take up item 33 out of order. So Chairman, Representative Scarborough, you're recognized if you'll come forward.
Motion.
We have a motion and a second on House Bill 2407. And thank you for your patience
No,
on this
sir.
very warm evening.
Thank you. You've covered a lot of ground today. I have an amendment, sir.
It is
015401.
15401. Have a motion and a second. You're recognized on the amendment.
Thank you, Mr. Chair, members of the committee. This bill allows qualified local governments the option to use additional project development methods alongside the traditional design bid build process. Current Tennessee law allows TDOT and certain other public entities, such as industrial development boards, to use various project delivery methods for construction projects, including design build method. However, local governments currently do not have the statutory authority to use the same time and cost-saving options. If local government meets the qualifications in the bill, this legislation will provide these additional project delivery mechanisms. The current process has become increasingly lengthy, expensive, due to extensive project timelines and rising construction costs. As a result, taxpayers often end up paying more for the same infrastructure projects. Our bill proposes the option of a design build for a project delivery method. It combines both design and construction services under a single contract with an entity. Cities across Tennessee are managed more complex infrastructure projects and tighter timelines. By adding this modernized project delivery method as an option for local governments, it will help them complete these projects more efficiently and responsibly. Mr. Chairman, if the committee wishes, I have representatives here from the city of Chattanooga and the city of Franklin here. They'd be happy to answer any questions.
I believe that I'm getting some feedback that we're willing to go forward on your amendment. And that's before us. Are there any objection to the question? Hearing or seeing none, those in favor of Amendment 15401 say aye. Aye. Opposed, say no. The ayes prevail. And we're back on the bill 2407 as amended. Are there any additional questions or comments? Chairman Crawford, you're recognized.
Move previous question.
Is there objection to the question? Hearing no objection, we're voting on House Bill 2407 as amended. Madam Clerk, open the voting board. Members, please cast your vote. Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 6 ayes and 0 noes.
The ayes prevail. House Bill 2407 as amended moves to the next available calendar of state and local government.
Thank you, Mr. Chairman. Thank you, committee.
Now, we will take up Representative Capley's bill. Item 31 on today's agenda, House Bill 1657. He's sitting, no, he's not here. No, he's not here. Okay. He was here. That's Himmer. Okay. All right. Did I skip his? Pardon me? Give me the mark. All right, well, where's? Okay. Members. I believe we've gone a good ways today. I apologize to the members who have been sitting here patiently, but I believe in fairness to the sponsors and to the members that we entertain adjournment, and we will hear these bills next week. Is there objection? Hearing no objection. I heard objection. Hearing no objection, we are adjourned.